Everyone, I have the pleasure to welcome you to this roundtable that we have co-organized together with Peter Hongler and the Clovedax Golf project at Leiden Law School. And this roundtable is about side-by-side between and having looking at the challenges in terms of what does it mean that the side-by-side system, and actually to discuss a little from different perspectives, different geographical regions, but also different approaches, including also the EU, looking at what this side-by-side agreement between the US and other countries will mean. So I will be the moderator until the Q&A, and the Q&A will be taken upon as moderator Jerome Monsenego, that will also add some main things to think about it. This meeting is recorded, except the presentation from Mohamed Matur, because he works for the Minister of Finance, and sometimes can be a little sensitive. But the whole of the meeting will be recorded, will be available in Clovedax Golf YouTube. And I see some familiar faces, some names that I know very well from the US, from Norway, from Brazil as well. So some very well-known friends, and I'm very happy to be here and to welcome everyone. Without any further ado, I will just give the word to Peter Hongler. He will set the scene. He will tell us about what he thinks about the side-by-side system and why is the reason that we need to organize this. And thank you everyone, to the speakers as well as to the participants to be here. Thank you. Please, Peter, go. The floor is yours.
Thank you, Irma, and good morning, good afternoon, good evening. Sometimes you organize roundtables for an audience, but this time I think we organized a roundtable for ourselves because the topic of side-by-side is so complex that I have not yet, fully understood what the implications will be. And I think that is a key problem here. We believe, or many believe, that side-by-side is something we can just implement, but that's not the case. Because it raises a lot of legal but also practical challenges, and of course the question of competitiveness will be addressed later on. So my goal here for the first 5 to 10 minutes is to give you an overview of the problems that are involved here, and so that other speakers then can address them with regard to their jurisdiction or their region or their specific topic. And of course it is good to start again with what is available so far. And available is basically nothing except for this famous G7 statement on global minimum taxes. And here I made a screenshot out of it to outline you the 4 commitments, because there are actually 4 commitments made so far. I'll briefly read them or basically summarize them. The first one is the most important probably for our roundtable. So a side-by-side system would fully exclude US parented groups from the UTPR and the IAR in respect of both their domestic and foreign profits. Now, what is important, of course, it applies to the UTPR and the IAR, but it does not apply to the QDMTT. However, important again to consider, it applies to domestic and foreign profits. So that's the first commitment. The second commitment, I call it the level playing field commitment. So at the same time, this should consider, that we will have a level playing field afterwards. The third commitment relates to, there is a need for material simplification. So it's not just about side by side, but also about simplifications. And the last one is on credits, so that post side-by-side, not only refundable tax credits should be considered good tax credits under the Pillar 2 rules, but also non-refundable tax credits if they're substance-based. So that is the agreement or commitment or whatever you might call that for the moment that has been published so far. And of course, as most of you might know, right now the negotiations are going on in Paris, and we have not seen any official publications so far. So in order to understand the complexity of side-by-side, I tried to categorize the countries, because depending on which category you are, the problems are different that are raised by side-by-side. On the left, I tried to categorize the countries depending on which rules they have implemented. because again, the issues and challenges are different. If you have implemented the QDMTT, the IIR, and the UTPR, you need to change the IIR and the UTPR because we have just seen that is commitment number one. But if you have only a QDMTT, as we will see later on in one presentation, well, then there might be not a need to change anything, but maybe you want to change something in order to remain competitive. So we can categorize countries depending on which rules they have implemented so far, but we can also categorize countries depending on how they have implemented Pillar 2 so far, because again the challenges are different. So we will have later on a discussion about the European countries, of course. There we have the Pillar 2 directive, plus in most European countries we have a domestic law implementing Pillar 2. So the question is, of course, do we need to change both of them? Do we need to change only domestic law, or is there no change needed at all? And then we have other countries that have only, implemented Pillar 2 through domestic law. And then even a very interesting category are those who have implemented Pillar 2 through domestic law, but refer to the model rules. So some countries have not copy-paste the model rules into domestic law, but make a direct reference to the model rules. And of course, that raises the question, how do you implement side by side in these circumstances? And the last example, that is my own jurisdiction, which I will briefly address, is Switzerland. There we even have a constitutional base. So we have a constitutional base just created for Pillar 2. Now the question is, does that constitutional base need an amendment due to side by side? So before we start with the other speakers here looking at different jurisdictions, let me briefly look at the model rules, because my understanding is, and colleagues please correct me afterwards, that side by side will very likely be implemented through a safe harbor, at least at the level of the inclusive framework. So the document will have the name safe harbor on it at the end, the final document. And then of course raises the question, what do we have in the model rules on safe harbors? And here that's an interesting provision, because it says, and I'm not reading the whole safe harbor provision, the last sentence says a safe harbor needs to be in line with the condition provided under the GloBE implementation framework. So that is a condition for any safe harbor. So far, we did not really discuss whether the existing safe harbors are in line with the GloBE implementation framework. But if you read the definition in the model rules on GloBE implementation framework, you will realize that the GloBE implementation framework does not yet exist. So the GloBE implementation framework means the procedures to be developed by the inclusive framework on how we agree on administrative rules, guidances, and procedures. And my understanding, and again, colleagues, please correct me, we do not have a global implementation framework so far. So there is no agreement on that. Now, if you have implemented the model rules directly into your domestic law, like some countries did, you face the challenge that the safe harbor provision basically does not give you the room to implement side by side, because a key condition is still missing, which is the GloBE implementation framework. So that is, a specific problem we will face in the future in those jurisdictions that have a direct reference to the model rules. And now just in 2 minutes, because that should not attract too much attention, the Swiss example is just very interesting because we have a constitutional provision. The background is the following. Our federation needs to have a constitutional competence to levy a tax, and the minimum tax was a new tax. This is why we had to create such a provision. And the provision reads as follows. The Confederation may issue regulations for large corporate groups on being taxed in the market state. So that was Pillar 1, and on a minimum rate of tax. Now, of course, the legal question that maybe will be dealt with by a court in Switzerland is whether post side by side, it is still considered to be a minimum rate of tax. Now, economically, what is side by side? side by side, if you have implemented the IAR and the QDMTT and the UTPR, it is a minimum tax on your domestic income plus CFC in a broad sense on non-US companies. So this is what side by side is, a minimum tax on domestic profits plus an extended CFC rule on all non-US parents. So that raises the question, is that still a minimum tax or is that something different? So these are my few remarks to get things started, and I hand over to Sean or Irma. Irma, you want to say something in between?
No, I think that I would just give the word to Sean. He will also do it from the, I would say, US perspective, but also tax foundation, because you say, well, not completely the US, but I know that if you have any questions, just please ask us also in the chat and we will deal with that because we have 2 hours, lots of speakers. So I want to give first opportunity to all the speakers to present and then after we will give questions. Please, Sean, go ahead.
Thanks, Irma, and thanks, Peter, for the beginning there. I'm happy to not only be from Tax Foundation and Tax Foundation Europe, but also be coming from an economics perspective. And I know there's a lot of lawyers here, so hopefully you keep track of my articles and protocols because sometimes I'm not the most straight on those. I'm going to try to do 3 things in the small amount of time I have. I'm going to briefly just talk about some of the history of how we got to the side-by-side. Because I think that's an important context to keep in mind as we're talking about this. I'm going to briefly go over the US system, which anyone who knows the US system briefly could be weeks, but I'm going to try to have it in a few minutes. And then finally, I'm going to end by just talking a little bit about what it means for Europe, which hopefully leads into our following speakers. So the first thing I wanted to mention is just I hope everyone keeps in mind throughout all of this process, not only the side-by-side, but Pillar 2 in general, that we are talking about rules that are going on top of BEPS 1.0. And I think that gets lost a lot of the time when we're talking about side-by-side and Pillar 2 and all of these things. I think it's just important to recognize first that all of these things are coming on top of the work of BEPS 1.0. Number 2, that's important to state, the United States in 2017 actually passed the first minimum tax under the TCJ rules. And I think, again, that's something just important to remind everybody because that also seems to get lost in these kind of current debates about side-by-side and who's right and who's wrong, etc. I wanted to read something to that particular point. If you forgive me for just reading, it says, the inclusive framework recognizes that an agreement on the coexistence of guilty and the globe would need to be part of the political agreement on Pillar 2. For those who have been paying attention to this for a very long time, this might sound familiar. It's from page 19 of the OECD blueprint from October of 2020. Not recently, not in the last few weeks, though it sounds quite similar to what we're talking about. So it was always envisioned kind of from the beginning of this whole process that side-by-side of some sort, at the time it was called coexistence, I think at some point it was also called equivalence, and now we're at side-by-side. The principle is the same. So this is not necessarily new. We've just come to the phase of what does it mean in practice. So I think that's something to keep in mind. And finally, kind of the background, which again, this could be a whole thing. Itai Grenberg has a great podcast that goes really far into, really deep on this point if you're interested. You might ask, well, what changed in between 2020 blueprints and the President Trump coming back this year? There are 4 years in between where the U.S. position sort of changed. I think it's just worth noting that the Biden administration tried to use the OECD process to increase U.S. taxes and unfortunately forgot that Joe Manchin and Kyrsten Sinema needed to vote in Congress to approve those changes, and therefore those things did not pass. And so if you're interested in that kind of story, Itai Grenberg has a whole podcast talking about sort of that failure of the Biden administration. I say that because when the Trump administration came back in, they wanted to go back to the 2020 version of the blueprint and kind of that theory of side-by-side, not what the Biden administration had tried to do of raising our corporate income, corporate minimum tax rates and expanding our corporate domestic tax rate to 28%. So all of that context, I think, is very important as we're talking about this, because this is not just a new thing that's happened. This has been talked about for a very long time from the United States perspective and kind of within the inclusive framework. For the US system, I think it's worth saying there was a report recently calling the US a tax haven, which I just think is silly, frankly. But it's worth saying why it's not a tax haven in this regard. We do have a domestic corporate income tax rate of 21%, which is higher than many countries that are in the Pillar 2 system. So we are not a low tax jurisdiction by any means. We have GILTI, which is now called NCTI for the Anglophones in the room. I think we've all agreed on necktie as being the appropriate way to say that. We've gone from GILTI to necktie, but the point is that it's actually more stringent than Pillar 2 in some respects. We can go into some of those details, but effectively, after OB3, the effective tax rate has moved up to 14%. So not exactly 15%, but 14%. It was lower under TCJA. But once you start thinking about kind of our less generous foreign tax credits, our loss carryover provisions, the substance exclusion provisions, and interest deductibility, you can argue that our GILTI now necktie is somewhat more stringent actually than an IIR under Pillar 2. So again, the idea that the U.S. is just some random tax haven that has no rules and therefore we need Pillar 2 to keep everything in check is just not accurate. The other thing that I liked to point out, which I think goes underrepresented kind of in the side-by-side debate, is the U.S. minimum tax is not just a IAR, it's actually a system. And so when we talk about these things, we should also be thinking about our BEAT provision and our CAMT provision, which is the corporate alternative minimum tax, and BEAT being the base erosion and anti-abuse tax. These three provisions interplay in very strange ways, which some I know Peter saw, and maybe some others have seen. Meta's recent earnings call, their effective tax rate jumped from 11% to 87%. And it's simply the way that our CAMT minimum tax provision is interacting with the new provisions under the OB3. And so I only bring that up to say that when we talk about the US system, we're not only talking about GILTI, now necktie, as an IIR, we're actually talking about we have three minimum taxes, and it's a system that interplays in weird ways on top of our 21% domestic rate. So I think the last thing I want to say about the US system, Section 899 was taken out of OB3 as part of the side-by-side agreement, but it has been very clear since then and up until very recently that Republicans in Congress are very happy to bring back Section 899 if there's no agreement. And so I think, again, as we're talking about this, the context is sort of tariffs, retaliatory taxes, what that could mean if there's no agreement found. To be clear, I'm actually not a fan of those things. I think they're economically damaging for both the United States and Europe, but it's worth mentioning at least that those in power think that that's a good idea and would use it if they needed to or thought they needed to. So my final point on the US system is that, in my view, side-by-side is the best option of the worst options. There are not really any great options, but it's the best option for now, with the caveat, if you think keeping Pillar 2 is the right thing to do. And that leads me to, if you are going to keep Pillar 2, you should have to explain what it's doing for Europe and why it's a good idea. We did a compliance cost survey over the summer with Taxation Europe and ZEW in the University of Mannheim. We worked with Professor Christoph Spengel, and we found that for EU-headquartered M&Es, compliance costs range for one-off costs from 1.2 billion euros per year up to potentially 2 billion, and ongoing costs of 517 million up to 865 million, with the caveat that ongoing costs could just simply keep increasing if we keep changing what's going on. But for now, that's kind of our compliance cost survey. So something to keep in mind when it comes to compliance costs for European M&Es of just complying with Pillar 2, a couple things: increased revenues may not end up in the same jurisdictions where the compliance costs are being booked. For example, increased revenues may end up in Ireland rather than in Germany, where those companies are headquartered and booking those costs. So the question really is for some of the member states, are these compliance costs worth it, and what does that do for competitiveness? A second thing I like to point out is that the way that the Pillar 2 rules are structured, it actually moves tax competition to subsidies rather than rates. And the EU, out of the US, India, China, and the United States, is the only jurisdiction that actually cannot raise its own revenue in a subsidy race. And so I always like to say that that might be a problem for the EU. We, of course, under the side-by-side agreement, are talking about the US, but I think it's worth pointing out the Chinese and Indian question of how this will work. And I know we have a speaker that will hopefully talk about some of that. And so my final point is that Pillar 2 is simply an international solution to a European single market problem. And we should be considering it in that vein. And hopefully there is a European solution to the European problem of raising Irish corporate tax rates so that Germany and France are not upset about it. I know that's provocative, and I will leave it there. Thank you.
Yes, thank you, Sean. I think it's very provocative, but it's also interesting to see that our next speaker actually will discuss the EU. So that will be also interesting to see what are also the challenges within the EU. So let's give the word to Martin de Wilde. Please feel free to ask your questions because we are trying as much as possible to make time for Q&A. And then if you ask your questions in the chat, we will deal with them during the Q&A. So this is idea to just exchange ideas to, like Peter says, a hobby of us just thinking about the side-by-side. We decided to organize something for everyone. So please go ahead, Martin, the floor is yours.
Yeah, thanks, Irma, for having me. Peter, thank you as well. Well, I also just saw in the chat a question. I think it was for Sean. I'm not sure if it's time to discuss it now, or perhaps wait until my talk is over. But
no, we can discuss it in the Q&A. I think that will be what.
Yeah, just one thought. I remember the talk about UTPR safe harbor, that we basically, for ETR calculation purposes for the UTPR, basically, that we introduced a statutory tax rate test instead of the Pillar 2 system, because of the, I think it's American ideas on potential UTPR top-up taxation in the EU on low-taxed American income from a Pillar 2 perspective. But I was just wondering if it is actually the 14%, it's more or less 15 or whatever with the SPIE and 15% ETR for Pillar 2. If it's actually equivalent, why would we worry about top-up taxation? So what would be the reason to have UTPR safe harbors? Because if it's equivalent, we would not have any top-up tax in Europe on American profits. So I was also wondering where's the tension? Because if it's actually the same, then I don't understand why we have this big year-long debate on this, because then it would be basically hot air that we are talking about. And then if it's not, then perhaps if there's actually a competitiveness question, and then I guess we will be looking for the potential ETR, like a delta between the Pillar 2 and the US minimum tax. I'm not sure, I'm not an expert in US taxes, but I was wondering, for instance, on the impacts of R&D tax credits and those types of tax incentives, because otherwise I don't understand why we have this discussion if there is no effective difference in the real ETR, whether there's a delta or not between these two, but I don't know. Nevertheless, my talk will be on basically the integrity of the EU's legal order, the rule of law, when we engage with OECD outputs that originate or have originated in political accords. So it's more of a legal analysis. So my talk will mostly be on this and more or less the meddling of that, the EU order, with if we try to channel OECD outputs into the acquis, basically by bypassing EU rulemaking procedures. So that's what my talk will be on. So first, to start, EU law rests on the rule of law and separation of powers. And it's also in tax matters. So the legislative procedure in EU lawmaking is the right of initiative in the hands of the European Commission, the Council adopting the proposals by unanimity, the European Parliament having an advisory role, and then the democratic legitimacy basically comes via the national parliaments who mandate their ministers, and that seeks to preserve in a graduate way the primacy of law in the hands basically of the people's representative. And also it reflects, I guess, classic constitutional tenets, no taxation without representation. And I think it's symbolizing also in the name of the tower of the building where the Court of Justice is. It's the Montesquieu Tower. And I think it's of importance when we consider also developments here involving Pillar 2. It was implemented in the EU via directive, in the EU Legislative Act. And the global tax deal is, at the end of the day, a political accord. It's not binding international law. OECD has no legislative inclusive framework, has no legislative or interpretative or executive authority. And that means that any of the outputs from the inclusive framework or the OECD cannot automatically become EU law. They must be translated into the EU's legal order, into the acquis. And then I think it's also relevant to note that it is the Court of Justice that is the sole interpreter basically of EU law, and the Court of Justice has asserted this role pretty firmly, I guess. For instance, in response to some challenges we have seen in the past on the relationship, for instance, between EU law on the one hand and national constitutional orders on the other hand, and we have had this big dialogue or perhaps even debate or perhaps even heated debate between the Court of Justice and the Bundesverfassungsgericht already a couple of years back on the purchase programs, on the constitutionality from a German perspective of these EU-based interventions, and then the Court of Justice saying, I'm the supranational court interpreting EU law that is of a supranational status. And indeed, OECD materials may, of course, in some instances inspire judicial reasoning, perhaps, but it's at the end of the day the Court of Justice that is autonomously deciding on the interpretative value of everything that is coming from Paris. And also the directive itself in the preamble says, of course, we can look into the OECD materials for illustration and for interpretation purposes. However, only to the extent it's in alignment with EU law. And then, of course, domestic rules, the implementation rules can be tested against the directive, but then the directive itself can be assessed and tested against primary EU law. And for instance, we see some examples in Court of Justice's case law on the beneficial ownership concept, for instance, in the Danish cases where the court took basically its own interpretation of the concept, took it from the interest royalty directive and put it into the context of an indicator for abuse under the EU abuse doctrines. And in the end, we have the legislative process in Article 115, and of course, recently the Advocate General opinion in the Belgian CFC case, basically, raising doubts as to the basis in 115 for introducing directives that combat tax avoidance. I wanted to mention it because if you ask me, it's avoidance, abuse is the yin, where the market liberalization is the yang, basically. So if we talk about market liberalization, fundamental freedoms, it's about market operators using their freedoms, but also it cannot be abused. So on the one hand, we have the use of the market freedoms, but it's not about abusing these fundamental rights, for instance, by aggressively planning your way into a lower tax rate on the basis of letterbox companies. And I think that is of relevance to note that we have this legal foundation. And of course, there's a lot of discussion over some potential openings to channel all these OECD inclusive framework-based outputs into EU law. To be honest, I think that these all are quite problematic from this lawmaking process. But for instance, we've talked already about interpretation, but also a basis that we often heard here is the safe harbor, so Article 32 of the directive. But if we look at international attempts to carry over all this inclusive framework safe harbors, for instance, via Commission statements, Council statements, and political statements, and at the end of the day, these all lack solid legal footing, and that risks breaching EU constitutional limits. We've seen the paper, for instance, of Weber the other day on the Plura blog, talking about the Meroni doctrine, some case law of the court, basically saying when we go, bypassing basically lawmaking procedures, it can be to some extent perhaps when we have some administrative ease observations, but when it's about tax policy, when it's about the substantive tax burdens and etc., it's something different. Then you would need to go to the constitutionally legitimized lawmaking procedures, and you cannot bypass them, and that would potentially lead to a breach. Even if you would already consider Article 32 saying if we have a set of international rules to which all the member states have agreed on, I also would consider, it's dependent on the interpretation whether you would see these term international rules to also include informal soft law policy documents. I would also tend to think that we would be talking here about, for instance, real hard law, public international instrumentation, nevertheless. I was interested also, Peter was showing Article 8.2.1, and we also have Article 8.2.2, giving a possibility for tax authorities to even challenge the safe harbor election by a constituent entity on the basis of a top-up tax interest under the detailed rules. Say that we have a safe harbor that is effectively functioning as a shelter for top-up tax exposure under the detailed rules, that would potentially provide the basis for the tax authorities to disregard or an election on the basis of the safe harbor rules. And I think that is of relevance because in practice, we've been talking about this topic, basically saying, but you should interpret this as something administrative. If you have the CBCR safe harbor and you put in wrong data, that could be a basis. But this is not, I think, when you read the provision. And also in the commentaries, it's about also the integrity of the Pillar 2 setup. Also echoing perhaps what Peter was already mentioning. If at the end of the day, a safe harbor becomes a shelter to shake off top-up taxes, potentially under a side-by-side or UTPR, safe harbor, whatever, that could be a basis for tax authorities to challenge that. And also considering the role of tax authority to levy and assess taxes on the basis of legislative acts, you can ask yourself what an individual tax inspector at the end of the day will do, looking at informal instrumentation without a basis in EU lawmaking procedures, and we have the legislative text under the directive. So I would be wondering at the end of the day what will happen there. We'll see on that. Of course, we've also the discussion on putting the notice in the official journal. Just recently, a commission saying, we can, on the basis of the tradition of the classic case law, 1960s, Van Gent en Loos, Costenel, giving direct effect to inclusive framework documents. But that too, at the end of the day, of course, is a bypass of the legislative process. And I think it's relevant to note that Van Gent en Loos, the 1960s case, was about the hierarchy of norms and the direct applicability of EU law and the supranational character. And this case was not about shortcuts to lawmaking. And I remember I had a chat with Lambert, it was also in text notes the other day, that perhaps you could go to legitimate expectations as a taxpayer. But at the end of the day, we also have legitimate expectations that are bound in for instance, contra legem. Can you really rely on that, knowing that we are effectively we've been bypassing EU lawmaking procedures? To what extent can you still rely on that when you know that we did not follow the procedure we have in the constitutional setup or the institutional setup of the EU on the basis of which we make EU legislation in tax? And of course, understand, that the Commission is wary about reopening the directive, the unanimity risks, potential challenges or reassessments of individual member states. Do we need the minimum tax, the competitiveness discussions, etc.? What if other regions don't implement Pillar 2 or are being allowed, to apply a different ETR level effectively? I'm not sure. We've talked about it already a little bit. But at the end of the day, I think it's of relevance to note here that this is so this part of the discussion is not about whether we think that these multinational companies should pay their fair share, of course, but if you do it, create something that is fit in the institutional legal order and the setup of the European Union. And I would also warn to against ideas of basically trying to instrumentalize almost like the court to import OECD political agreements into EU law without a proper legislative procedure. And I don't think that, I would think it hard to think in terms of the court being willing to be used for these types of purposes. So I think also in view of what we saw with in the discussion, for instance, with the Bundesverfassungsgericht, that the court will really be looking into that matter. What is the legitimate basis here for all this channeling of OECD documents into the acquis? And I think at the end of the day, it's about how in the EU legal order we protect the trias from any attempts to go importing any non-binding international materials into the supranational EU law without following proper legislative procedures. I don't see that happening, to be honest, at the end of the day. We just need to make changes to the directive and follow the oil route. So thank you.
Thank you so much. And for the ones who are not familiar with the European, the word that Martin just mentioned in German, the Bundesfinanzgericht.
That's the German Constitutional Court. Yeah, sorry.
Yes, German Constitutional Court. I cannot pronounce it myself. So just to let you know. So thank you so much, Martin. I think that there are some issues regarding EU. We know also that there are Elodie Lammers from the Taxons International. She just published some notes on that 2 weeks ago. And we think that there is a reason why we also want to discuss the EU perspective. And feel free, everyone, also expert in the EU, to give your thoughts on this in the chat, and then after we have the discussion. But since I want to give the floor to the next person, then we will go to the 3 countries, I would say, perspective. Some of them speaking in the personal capacity. So first we go to Suranjali, China, and a little of more India and a little of China, perhaps. But then after we go to Andrea Laura Riccardi, who will be in her personal capacity discussing about Latin American countries. And then we conclude with Mohamed discussing Matur from the Dutch Minister of Finance. So please go ahead, Suranjali, the floor is yours. And for everyone, please ask your questions in the chat. We will have time to address them with Jerome as the moderator.
Thank you, Irma, and thank you, Peter, for inviting me for this. I think it's quite important to talk about this topic by zooming out from EU and looking at it from the perspective of countries like India and China that are still not ready to introduce a Pillar 2-like legislation domestically. And I think it kind of goes back to the very basic question of why Pillar 2 was introduced and who is it to benefit. Of course, we're all familiar with the statistics that the large share or the coverage of Pillar 2 was US MNEs and EU-based corporations. And for India specifically, I could say that, there were not even a handful. I think there were about 2 to 3 companies which would really fall in the ambit of Pillar 2. And so the question that the administration raises for itself is that what's the benefit for me to comply with this new rule as opposed to the costs of bringing in administrators who can look at such information, process such information, and also share it. Now, of course, this creates complications because countries like India and China would be required to share information with countries that are headquarters of these MNEs or where the parent entities are located. And the question that remains is that if the side-by-side arrangement does exist, then if India does not have a local legislation, how does the information get shared with the EU and how does it get shared with the US? What kind of an arrangement would exist? I think it's also important to look at the context of whether these countries can introduce something of the sort of globe, or would they also have to follow the side-by-side arrangement. And I think in that context, again, it's important to understand that legislations which are not very aligned with or agreeable to the US are not possible for countries like India and China. We've seen that with the digital services tax, India now got rid of its equalization levy because the free trade agreement was being negotiated. And my sense is that this was an attempt to say that we do not take unilateral measures. We're sort of going to go for an agreeable position on international taxation. So then again, having a rule which would be more aligned to the US, perhaps, if at all it ever comes into play, may be more agreeable for countries like India and China. The interesting thing is in the statistics again. So who does it really impact? Where would these collections really arise? And of course, these numbers are a little dated, but if you look at the US MNEs operating abroad, there's information on that, on the effective tax rates and incomes reported. If you see, largely the problem that the United States had from its MNEs and its affiliates located abroad was in jurisdictions like Ireland, Switzerland, the Bermuda, and the Caribbean islands. So in a sense, the effective tax rates were very low. They were below 15%, and the revenues were quite high, reported in these jurisdictions. So any application of Pillar 2 would actually bring revenues from these jurisdictions. So my sense is that while the EU may, of course, sign this side-by-side agreement, what does it really mean in terms of revenue gains, even to the EU, is a big question. And I think this is a question that the EU should reflect a little bit more in the context of competitiveness. The presidency is centered around bringing more corporations and the growth of corporations. There's of course a cap on the way subsidies can be offered within the EU. And if of course this minimum tax is to apply, it basically means that there will be some loss of competitiveness within the EU and vis-a-vis the US corporations. And now it really depends on how these two laws operate. So my summary for countries like India and China is that it is a high compliance measure with low revenue gains. There's no foreseeable, I would say, enthusiasm to adopt something similar. And of course, with the trade relations with the US, the design of any such measure would have to be more in line with what the US may prefer. That being said, the revenue gains remain limited. Thank you.
Thank you so much, Suranjali. And I will give now the word to the other side of the going through Europe and going over to Latin America. I know that there are also a good friend of mine from Argentina there. So you also from Latin America, we have some attendants, some participants, but I give the word to Andrea Laura Riccardi, and you are speaking on your personal capacity. But please go ahead and tell us a little about the side-by-side system and how do you see these reflections. Thank you.
Okay, thank you, Irma. And before starting, let me thank you, Irma and Peter, for the invitation. It is a true honor to be at this roundtable with you and the rest of the participants. And as you already mentioned it, but my usual disclaimer is that these are my personal views and do not necessarily reflect the position of the organizations to which I am affiliated. So first, let's see the global minimum tax implementation in the region. Well, in general, jurisdictions in Latin America and the Caribbean are net capital importers, are not the seat of the headquarters of these MNE groups under the scope of the GMT. So this, from an international income tax perspective, means that they are mainly source or market jurisdictions. And this is why the implementation of the IIR has not been that attractive for the region, neither the GMT backstop rule, the UTPR. So Latin America has been addressing the GMT mainly from a low tax jurisdiction perspective, and therefore has focused on analyzing either the reform of their corporate income tax systems, including the adoption of a domestic minimum tax, a GMTT, and possibly QDMTTs, as well as the reform of their policy to attract foreign investment, including tax incentives. So, and contrary to what has happened in Europe and parts of Asia and Oceania, in general, the region has not moved forward in the implementation of the GMT. Just a few countries have enforced legislation. Bahamas, we have Barbados, we have Curacao, and Brazil that have adopted a DMTT. And the first two as of 2024, and Curacao and Brazil as of 2025. Brazil and Barbados DMTTs have already the status of QDMTT and QDMTT safe harbor according to the Inclusive Framework Transitional Qualification Mechanism, and only Curacao implemented an IIR as well. And Uruguay, my country, may have its DMTT probably, and at least this is the intention, a QDMTT approved by the end of the year, but in effect as 2025. So also Colombia, we have Colombia that has implemented a DMTT of 15%, la tasa de tributación depurada, that has not the qualified status, which is in force as of 2023. So other measures include, for example, the participation of Peru and Jamaica in the pilot programs aimed at helping developing countries to consider their policy choices that the Secretariat of the Inclusive Framework established in 2022. But as the implementation of the GMT has not been that strong in the region, and Latin America and the Caribbean remains still in a waiting and seeing position, let's say. Which, considering the lack of the stability of the measure of the GMT and the uncertain international scenario, seems still reasonable. And in fact, this has been the position that I defended, and I think it is not time to move forward, for a variety of reasons, but most importantly, because there are substantial aspects of the rules of great importance for the region, not defined yet. And for example, we can mention the treatment of tax incentives under globe calculations and the non-benefit requirements of the rules, including the QD entity. But in any case, and focusing on the QDMTT, which is the measure that some of the countries in the region have taken, we can wonder, question how would the side-by-side agreement affect the entity, QDMTTs implemented or being implemented in the region. So as mentioned, the G7 agreement only refers to the application of the IAR and the UTPR, let's say the extraterritorial rules of the GMT. As per the first principle we saw when Peter made the introduction to this roundtable. But in relation to the QMTT, it expressively states that discussions were informed by, among other elements, consideration, it says, of the success of QDMTT's implementation and its impact. So it seems that the assumption is there would be a widespread of implementation of QDMTTs, including QDMTTs being applied to constituted entities located in QDMTT's jurisdictions, but that form part of US parent groups. So the side-by-side agreements will not deactivate QDMTTs, that seems clear. On the contrary, in a post side-by-side agreement scenario, it seems that the QDMTTs will gain importance. So some considerations that are not intended to be exhaustive, of course. One first question I will pose is what happens if a DMTT that does not apply to constituted entities that are part of US parent groups under the GMT, what happened? No? So, for example, I can share that the bill that is introduced in the DMTT in Uruguay establishes that the executive branch, it says, shall exempt or exclude from the tax, so the domestic minimum top-up tax, those constituted entities located in Uruguay that are part of a multinational group whose ultimate parent entity is located in a jurisdiction that has been exempted or excluded from the application of the IAR and or the UTPR. So this is the side-by-side approach. So can this DMTT be considered a QDMTT and further be qualified for the QDMTT safe harbor? So if we say it cannot be a qualified DMTT because it is a conditional, kind of conditional DMTT, the following question would be, what is the consequence of this? I'm wondering this because in any case, you know, under the agreement, the IAR or UTPR won't apply to low tax constituted entities that are part of a US parent group. So what is the consequence of the non-qualification of this domestic minimum top-up tax? A second question to consider is how would the US minimum tax system foreseen for foreign CFC income interact with QDMTTs? So there we can mention the subpart F for passive and mobile income and the net CFC tested income, formerly guilty on active income. So just a reminder, in the 2023, the administrative guidance confirmed that guilty met the definition of a CFC tax regime under the GLOBE rules. Besides, this administrative guidance state that guilty is a blended CFC tax regime and establish a simplified allocation of the blended CFC tax to individual jurisdictions for the GLOBE calculations. But this was established for a limited time period. And under the modal rules, you know, the principle is that cover taxes follow the GLOBE income, and CFC taxes are supposed to be pushed down and allocated to the CFC and taken into account to compute the ETR in the jurisdiction of the CFC. But this, however, applies only for the calculation of the top-up tax that will be captured by the IAR or UTPR. For QDMTT purposes and the computation of the ETR, CFC taxes shall be excluded. So this ordering rule, as mentioned in the commentary, is aimed at attributing primary rights to the jurisdiction applying the QDMTT in relation to its constituted entities. So in principle, because I think it is part of the discussion, US minimum tax systems on foreign CFC shall be considered as CFC taxes. These are taxes paid in the parent jurisdiction on income obtained by CFCs, and that cannot or shall not or shouldn't be pushed down for QDMTT calculations. So, and at the same time, QDMTTs, I think that should be credited against US cross-border taxes. A third consideration is on tax incentives, and this is because because of the fourth principle listed in the side-by-side agreement already mentioned by Peter. This is the consideration of changes, it says, to the Pillar 2 treatment of substance-based non-refundable tax credit that would ensure greater alignment with the treatment of refundable tax credits. So I think that this fourth principle may benefit the region. And why is this? Because, you know, the big challenge for the region in a post-Pillar 2 scenario is the foreign investment policy. As you know, the GMT impacts the effectiveness of tax incentives, and it distinguishes between good and bad incentives by granting them a different treatment under the calculation of the top-up tax. So, and in particular, the GMT is making countries move to this new concept of qualified refundable tax credit, which are the more, let's say, GLOBE compatible incentives, as they are the less affected. However, we all know that for less developed countries, including the region of Latin America and the Caribbean, these types of credits are rarely granted as fiscal space is very limited and there is no administrative capacity. So with this fourth principle, if we look at the glass half full, the US demands under these side-by-side agreements may provide greater flexibility in respect to tax incentives and in the end may benefit somehow the region. So I can leave it here and thank you.
Thank you so much. And I think that it's very interesting to see the views and the thoughts from Latin America and also what the countries are doing. And also we have heard a lot about the tax incentives. So we can also, Jerome, I give the word to Jerome. Jerome, please go ahead.
Thank you very much, Irma, and thank you to all of you for all these interesting thoughts. I will just have mention a few ideas and raise questions to actually to all of you. The first thing is that if you think about the link between tax rules and whether it is soft law or political statements, we're already struggling with transfer pricing. Can we apply the transfer pricing guidelines? Can we apply them retroactively? It's already complex. We do the same with tax treaties. Can we look at the commentary? Is it binding? What happens if the commentary comes later? It's already complex. And when we look at Pillar 2, it's much more complex because it's not a matter of principle. It's a matter of material rules. Which rules we apply, in which rule order, when are they qualified? It's, in my opinion, much further reaching than whether transfer pricing or tax treaties. And with that, my point is that I think we need a strong bridge, I would say, between domestic rules and the international work, whether we call that soft law or political statements or administrative guidelines. I think we need a stronger bridge. And also in terms of I think Mohamed, you mentioned the legitimacy of the project, the role of national parliaments. I think if we want to continue working with global projects and if we want them to receive sufficient trust nationally, we need also from that perspective to have what I would call perhaps a sufficient bridge between what is agreed to on an international level and how it is implemented domestically. And if we indeed try to look a bit closer into this sufficient bridge, and if we look into the situation of the EU, this is when I'm going from thoughts to questions. Several of you have been mentioning the Article 32 in the directive. Personally, I'm a little bit let's say, wondering to what extent we indeed can implement the side-by-side statement or agreement, if we want to call it this way, through the safe harbor rule in Article 32. And more specifically, I'm wondering whether we can find that as a qualified international agreement on safe harbor. And if we first start to understand, perhaps think about what is meant by the directive, this is already difficult in itself. I don't really know what the directive means. And if you look at different versions of the directive, it uses different expressions, different words, and different languages. But those different language versions have, in my opinion, different meanings. In the English version of the directive, it is the word agreement that is being used. In the French version, it's the word convention, which from a civil law perspective is a legally binding contract from a civil law perspective. Tax treaties are also described in French as convention fiscale. If you look at the Swedish version, the word used is avtal, which is also a legally binding contract. So it sounds like something legally binding, which would be here glad to hear whether you believe that this is indeed something legally binding, and if it is not, can we indeed at all consider that whatever solution is agreed to within the inclusive framework, if that works under the safe harbor, especially if we look into how we should interpret Article 32, not the least in the light of the preamble, paragraph 24, I think was mentioned, which is not really necessary. Basically says that whatever we do, it needs to be consistent with the directive. But Article 52 of the directive about equivalence is very clear about the fact that we need at least jurisdictional blending, which makes it more difficult to agree to this side-by-side solution. So that's the first question. A second question would be, what if certain member states do not implement the solution? And we've heard that maybe a third of the member states do not really believe in this situation. could we imagine the European Commission starting an infringement procedure? Could that end up in the court before the Court of Justice? That was already mentioned, but what would happen then is, of course, an interesting question. I'm also have a question for you with regard to what we could say is not one of the 4 minimum standards of this side-by-side solution, if I can say so. But the following point, which is basically about stabilizing the system and pursuing a constructive dialogue with respect to the taxation of the digital economy. So keeping the door open to Pillar 1 or GSTs. So if this side-by-side solution is not successful, can we expect that discussion to come back, and could that be used, let's say this kind of threat from this point, which is not one of the minimum standards, just an additional point, could we use that to try to push a solution at the global level? And then my final question, which is really an open one, is what lessons for future global tax projects? I'm thinking about some existing ones. I'm thinking about the European CBAM, for example. Is that comparable? It's a kind of minimum tax or levy, but it's at least philosophically comparable, I would say, to Pillar 2. So existing global projects, and future global projects as well, whether it's like a minimum tax on ultra high net worth individuals or other types of projects. What lessons should we bring with us to those future discussions? I want to be optimistic and believe that there will be more global discussions, more global projects. But I think this has been like a perfect school case to test I would say the readiness of different countries in the global tax community to move on together and see to what extent countries are really ready to compromise and accept different views. And when we're testing these, I would say these borders, they tend to crackle perhaps now a little bit. So what lessons, both in terms of, let's say, material rules and governance as well, what lessons for future projects? And with that, I would like to give back the floor to the speakers to kind of bring some answers to these questions. And after that, I think we can go to the general Q&A session. I promise, Irma, I won't be speaking, just giving the word.
Yeah, Irma, should I start?
Yes, please. Martin, please.
Yeah, well, everybody saw I was chatting with you lovers, but nevertheless, there is no, I was not saying any secrets, but indeed, what I also mentioned there is if we take our rule of law serious in the EU, and I think if you look at Article 1 or 2 in the Treaty on the EU, it's part of the EU culture to respect, well, and that the charge, for instance, to tax should be based on the law. And if you say, yeah, sure, we have Article 32 and we have all kinds of informal soft law stuff we produce in Paris, and like magic, we elevated into the EU acquis, giving it supranational status. Yeah, but that cannot be the case. You know, it's I think it's almost like and to put it dramatically, a flagrant infringement of the entire concept of how we make and create law in the law legislative acts in the EU, in the EU institutional order. Particularly considering that many of the safe harbor stuff is actually substantive stuff, rather than just like a form and whatever, some administrative things. So if you actually respect your rule of law, as you say you are in your foundation treaties, you should do it also when we start taxing companies. And you could say, yeah, sure, tech companies, and we have they need to pay a moral contribution to finance society. That of course, sure. But at the end of the day, also companies, also businesses should have the right to be subject to a tax charge, having a foundation in a legitimately basis, respected basis, and adhering to the legality principle and all that stuff. So no, I don't think that Article 32, when we look at international agreements and what you were mentioning, yes, of course, it should be at least legally binding before we could give it a okay into EU law. So I have to. Yeah, perhaps I'm a lawyer because it's me being a lawyer, but I don't think we should pay lip services to to the EU trias here when it comes to taxing multinationals because it's politically convenient to do it that way instead of breaking or opening up the directive. To be honest, yeah.
Thank you, Martin. Fair enough. Thank you, Peter.
Yes, I'm a lawyer as well, but I want to keep things simple here. When the project started, the OECD issued every other week new estimates on what the revenue will be from the whole project. So let's assume it's 200 billion. Now, I want to hear now, before there is a decision, an estimate on what will be the remaining part of it if the US is out of business here, so if side-by-side is implemented. Let's assume 2/3 of the 200 billion should have been levied from US multinational. If that's the case, and maybe, that is quite close to the actual number, side-by-side is the biggest tax exemption in the history of the European Union. And as a non-lawyer, I would say I need a political decision about that by, the body that should do tax policy. And this is not going to happen because we will sneak it through safe harbor. And that is what, raises a lot of concerns. And I'm not from a European country. I mean, not from a new member state, but I have severe problems with, enabling the biggest tax relief in the history. And now I make it a bit more emotional. We could build a lot of schools with that money. But somehow, that is not going to happen. So that is just a non-legal, a bit of an emotional rule of law perspective. Thank you.
Fair as well. Thank you. Schoen, the floor is yours.
Thanks. I actually can pass it to Jerome just for a second, and then I can answer. I'm trying to collect questions and answer all together.
All right. Thank you so much. Thank you for all the presentations. Very interesting. I was just going to add, so I'm at the Copenhagen Business School, and yesterday Benjamin Angel was with us, said many of the same things. And my thing here, and like Peter, I also like to keep it simple. He compared the 14% rate with the 15% rate of the Pillar 2, but obviously the big elephant in the room is the jurisdictional blending, yes or no. So yes, 14% might be applicable under guilty or necktie, or what is the acronym now exactly? But the point is that is a blended across the rest of the world instead of the 15% blending on a jurisdictional level, which makes the ETR actually quite different from US parented multinationals and EU parented multinationals. So the competitiveness issue is, I think, still very much on the table. It's not just equivalent. And then Peter's comment on how much does that cost? I think that's a very relevant one, and directly tied into that is what is actually the policy response on the QDMTT of countries? Because if the QDMTT stays in place, then actually the revenue might not shift around a lot. But if if jurisdictions then want to cater holding companies to US parented multinationals, abolish their QDMTT, then the shift will definitely happen. So I think that those things are really, really relevant. And this is also why I support Martin's argument that this is not just a royal route. You need to have political mandate from the council to do this. The question is not, can you do this without changing the directive? The question is, why would you even consider doing it without changing the directive?
Thank you, Sharon. Sean?
Yeah, thanks. I had a feeling you might bring that up, Jerome, so I'm glad I let you go first so I can include it a bit. So I just want to respond to a couple things that I've heard throughout here, and also the question I think in the chat almost an hour ago. So thank you for waiting to Luis. A couple things. So I think that's why I wanted to bring up the fact that we have BEPS 1.0 and TCJ was the first minimum tax in 2017, because I think the bigger picture here that we all seem to forget sometimes is why are we doing this? What is all of this about, right? One of the comments was a lot of this was about US M&Es and it was about inversions in Ireland, and that's why we need Pillar 2. Well, I don't buy that point, actually. We have BEPS 1.0, and the TCJ reforms under Necktie and all of the CAMT and BEAT, I think it really did change the way that inversions were happening from the United States into, for example, Ireland. We didn't give enough data time to actually analyze that question before we slapped Pillar 2 on top of BEPS 1.0 and the TCJ reforms. But I think when we're talking about who needs to adapt to who and how these things should come together, it's not only a technical question, but it's also a political question. The United States had the first system. And so to the question earlier about should the US adapt its system to Pillar 2? Well, why? It's the inverse, which I think is what we always forget. The system existed in the United States and it covered a large portion of the international system because the US M&Es make up a large portion of the international system. So what we're talking about on top of BEPS 1.0 and TCJ reforms, we're talking about the rest of the world, and how the rest of the world is going to conduct itself vis-a-vis the TCJ reforms and the CFC rules that we all passed under BEPS 1.0. So that's really what we're talking about. And the other important point there is that the US has a worldwide system, and we conduct business on a worldwide system. So when we pass GILTI, now Necktie, we're more interested in changing the behavior of US M&Es than we are changing laws in foreign jurisdictions. That's why we use a blended system and not a country-by-country system. We're less interested in governing Irish tax law or governing the Cayman Islands, and we're more interested in the behavior of our companies and how it affects our US tax base. Pillar 2 obviously has a different mindset in that regard. And I think a lot of it is driven by the fact that most of the rest of the world is driven on a jurisdictional basis, not a worldwide basis. So I think it's important to understand which one came first and which one should adapt to which, and why we're even doing this to begin with, which again, I come back to, why is Europe doing this? We could have done this within Europe if we wanted to, right? We could have had a minimum tax. Europe could have introduced a harmonized tax rate in Europe. They were trying with the base forever with CCT2B and BFIT and all these things. I wanted to make a kind of controversial point. I think there were two deals made with the devil. And in this case, the devil is the OECD. I love the OECD. I love their people. And I respect their work. It's just a turn of phrase, okay? To your point, Jerome, about kind of future lessons of tax policy. There were two deals made with the devil, and both of them turned out pretty bad. The first was the Biden administration thinking that they could use OECD pressuring and quote unquote credibility and legitimacy to force the US Congress to change congressional law and tax policy in the United States. That completely backfired because, unlike in Europe, and this is the second deal that was made, the European Commission politically thought, well, it's easier to go through the OECD to change European harmonization laws than it is to go through the Council and through our normal procedures, because OECD credibility and legitimacy carries a lot more water in Europe than even our own process. It's very hard to get Ireland to change their rules, but if we go through the OECD, there's more pressure and we can do it that way. Well, the Biden administration failed because the US Congress said, well, actually, we make tax laws in the United States, not the OECD. Thanks for trying. Come again later. We've already done this in 2017. We don't need to go through this. In this case, now we have the legal questions about how to change European law because it's being dictated through soft law from the OECD into European law. So that's what happens when you make this deal. That's what happens when you use the OECD as a credibility and legitimacy tool to make European laws and regulations. Well, then you actually outsource some of your legislative power to the OECD. And of course, the legal questions come with that. Finally, I just want to point out, Jerome, and you mentioned CBAM, and I think that's something where I would give hopefully some advice. The US, for all of its flaws, it has many, we're all aware of them. They try to legislate what's best for US companies. That's what they try to do. They fail a lot of the times. We have a very complex system. It's not competitive even in our own International Tax Competitiveness Index at Tax Foundation. But the goal usually is, again, the worldwide system, we tax our companies, we're less interested in the Cayman Island tax policy. Europe under CBAM, under Pillar 1/GSTs, Pillar 2, all of these things, it's more interested about making tax laws in other countries than it is in their own. And that puts Europe at a disadvantage competitively when it's more focused on changing other people's laws than it is about changing their own laws. I know that's controversial. I'm trying to stir debate here, but I think it's worth at least pointing out that in any future tax policy discussions, I would hope that Europe focuses on Europe and what's best for Europe and what's competitive for Europe, rather than trying to go through all these other routes that lead to problems. So I'll stop there.
Thank you very much. I'm looking at the chat. There was one question addressed to Andrea. Andrea, you responded shortly in the chat saying that you would agree with what was mentioned. So I'm asking whether you would like to provide some more answer, or if that is sufficient for now.
Thank you, Jerome. Yes, I absolutely agree with what Gabriela was suggesting. I really think it's not time for the region to move forward. And as mentioned, I mean, I shared an article, a blog post. Irma very kindly acceded to publish at the Globe Tax Gov. With some arguments, but mostly because, as mentioned, I think that there are so many things to define, so many things that are very important for the region, especially tax incentives, foreign investment policy, that if we are implementing legislation right now and we don't know how this could end, I think that, and we do not have much resources, you know, so then I don't see the point here. I think that it is clear that this is, you know, a conflict between US and Europe, and we are in the middle. And yes, and I see Gabby here. She was sharing with me some very interesting views. And yes, it's like that, you know, we are, for example, and it's very from a personal perspective view. Uruguay is implementing this DMTT, and we have a very strong tax incentive policy. And apparently, yes, there are suggesting that we are going to introduce some refundable tax credits, very vague legislation, draft legislation. And, you know, it's our strong, you know, element here to attract investment, and it does work, you know, like for example, free trade zones here have lots of indirect effects in the economy. They provide lots of jobs. Salaries that are paid there are above the average salary paid in the market here. We are a very small country, very far away. We are not a big market, so this is our strong, you know, and we are, you know, feeling quite, you know, obliged to adopt some measures that really do not benefit us. And yes, so we are not. We were exchanging with Gabby. We are not a tax paradise. You know, we have our, you know, tax principles, and yes, we have our tax incentives. But these are not like paper companies. They have substance. They provide jobs. They move the economy. They increase exports. So well, I think that Jerome, I shared the blog post there in the chat, so participants can have a look at that. Yes.
Thank you very much, Andrea. Thank you. Then there was a question from Elodie to mainly to Mohammed. Maybe I don't know if you've seen the question, Mohammed. The first one is whether you see any legal or constitutional issues with using Article 32 to implement the side-by-side system. We've been talking a little bit about this, but whether you could deepen a little bit this aspect. And here the question is also mentioned that the Commission, of course, would consider publishing a notice. What do you think about this? And what if the parliament rejects the side-by-side? Would the notice then supplement the rejection of the parliament, to supersede it? Second question is whether what do you think about the request of Estonia to allow a small country exemption from Pillar 2? Before I turn to Jean-Philippe, there was actually a question raised earlier on the chat that received a small answer, but the question was nevertheless asked to Sean. Maybe he would like to get a chance to say a few words, whether there would be possibility of, while maintaining side-by-side, the US would change its legislation to get closer to Pillar 2. It did to some extent with the necktie, but could it go further? Or not. And here there was a comment in the chat saying that the US, that there is a pending proposal that would end up guilty blending, so end up global blending, moving to more to jurisdictional blending. So Sean, do you have something to add in this respect?
Yeah, it's just building off my previous comments. I mean, the Democratic Party in the United States had control of all the levers of power, and they attempted to do something similar, and it did not go through. The Republicans now control all the levers of power and did not attempt even to do that, and they passed OB3. So both parties have had their chance, and both have passed on attempting to do that. And yes, while there is a bill co-sponsored in the House, I don't see that happening anytime soon. The reason is twofold, as I was mentioning. From a technical perspective, our system and the Pillar 2 system are different methods that result in similar outcomes. The question about blending and country by country is always raised, of course, and what I want to say about that is two things. At a technical level, blended, you can blend over jurisdictions, but not over time. And Pillar 2 is the opposite. You can blend over time, but not over jurisdiction. So you can't have carry forwards on your foreign incomes under our system from year to year. So yes, you can blend across jurisdiction, but you cannot you blend over time, essentially. And Pillar 2 is the opposite. So there's a lot of details, and I would refer many people to Mindy Hertzfeld's most recent article on kind of the side-by-side and going through the US system. She goes through everything in really great detail. But that's one of the examples where I could give where the blending is not as big of a deal as I think it's being made to be. The second thing, of course, is if we did go to country by country, it just increases compliance costs. And the question would be, for what purpose? Again, this goes back to the fundamental question of, is the goal of the US policy or Pillar 2 policy to change everyone else's laws around the world? Or is it to stop base erosion from your own base? And in our system, the blended version, it effectively stops most of the really egregious base erosion that was happening prior to BEPS 1.0 and prior to TCJA reforms. And so the question then is, okay, so if we go to country by country and we increase all of these compliance costs, what exactly would we be benefiting from doing that? Other than saying we fit the formula of Pillar 2. Well, we don't need to do that because we were first, and the Pillar 2 system is building around our system, not the other way around. So if there's no technical reason or outcome-driven reason that we should do that, there's certainly not a political reason for us to do that. And so the question is, why would we do that? So that's kind of the basic point. But I would really point everyone to Mindy Hertzfeld's article, because she did a great job explaining the details of these things.
Thank you very much, Sean. Jean-Philippe, the floor is yours.
Thank you, Jerome, and the organizers for this event and the excellent presentations. My question was more related to the topic before, so that's why I raised my hand at that time. It's respect to the side-by-side deal. So it was discussed. There are several potential legal issues regarding the implementation of the side-by-side deal, although that we don't really know how it will exactly look like. And I think both was discussed at the constitutional level. I think you can say, well, if you're an EU company, you have a US parent, you're potentially out of the system. You're EU multinational, but you have an EU headquarters, so a parent above, you're subject to it. Is this discrimination, non-discrimination? What is the rule of that? But as well, particularly from an EU law perspective, as well as, so you say, if it goes to via Article 32, safe harbor, is that the correct way? Potentially, I think if I hear Maarten and Jeroen say clearly we need a change of the directive, unanimity, which is obviously would be the better way, but well, we have this unanimity requirement, so I understand they want to, from a political point of view, policy point of view, they want to circumvent it. But my question is, what if you say, well, there's doubt, potential debate, what are the things, the potential that you see that the outcome of the side-by-side green will be challenged and be challenged in constitutional courts, will end up before the Court of Justice? Do you have any views of that? Because on the one hand, we already have with the additional later guidance where you say, at some point you say, well, is this really in line with the directive? The Commission says, well, it is all in line. It's all fine. No issue there. So from which you can derive potentially the European Commission will not start an infringement procedure, and is it in favor of the taxpayer? Taxpayers will not challenge it either. But with this one, you might see, well, if there is a competitive disadvantage, there might be companies which have, or business federations who say, well, we have an interest in challenging this. So on the one hand, do you think the views that will be challenged? And maybe in that regard, it's good to remind the case before the Belgian Constitutional Court, where it was a US business federation who challenged it before the Belgian Constitutional Court and ended up before the Court of Justice. And if it's challenged, what do you think will be the chances of success? Because there as well, you hear different views. Some say, well, from a legal point of view, you might have a valid claim, but from a business point of view, or like, or how will the the Court of Justice, will it really undermine a global deal? So would be happy to hear your views on this.
Thank you. Well, I don't know who would like to answer to so many questions. One might wonder to what extent there is an interest in acting if indeed the side-by-side becomes implemented, because then some of the issues become less patent for American businesses. But apart from that, indeed, it's going to be extremely interesting to see what happens in this respect. Maybe that's a question for European members of the panel, or actually anybody I would say in the room is more than welcome to give some thoughts in this respect.
Job, I could kick off,
of course,
perhaps. Well, first, I enjoyed listening to Sean. To be honest, I also enjoyed reading the letters from U.S. Parliament to the OECD over the years, basically saying the power to tax U.S. taxpayers rests in the hands of U.S. Parliament, and I also think it's refreshing to hear that U.S. is seeking to find a tax system that suits the interests of U.S. Taxpayers. It would be refreshing if the EU would start doing something similar. But yeah, if I also read the Hersfeld's paper, and something that is still puzzling me, if it's actually the US is more rigorous, if the ETRs are more or less the same, then what is the discussion about? Because then it ends up in being some technical stuff, and then there wouldn't be some political discussion. And I would agree with Jean-Philippe's comments. Sure, if it is all for the better of European companies, there wouldn't be any claim filed before the court. But at the end of the day, if we would end up in a scenario where we would have European companies being subject to a higher tax cost vis-a-vis American competitors, then there is a business interest to start suing and to litigate. And then we will end up asking ourselves, is the Pillar 2 directive, is all this side-by-side stuff binding? And is it secondary EU law? And if it is, does it relate to primary EU law? And then you will end up with non-discrimination claims. For instance, you end up with questions like, can the EU legislature introduce state aid for American companies? If we end up with an effective delta in the ETR, then there is an interest to litigate, because then we will end up with this place that European companies will be subject to higher ETR effectively than US competitors because of the side-by-side. And then you will have a target in court to litigate and an interest. So I think it's all about the question: do we actually, is the discussion about competitiveness? Is this question about the effective tax cost under the two systems? Or is this just technocratic or technical stuff and there's no political interest? And if it's the first, I understand why we have this big debate. And if it's the second, I don't understand. And my intuition would be, I think, that I have a feeling that tax incentives, the US that US tax incentives and the US minimum tax system is designed in a way that US tax incentives are not taxed away with US minimum tax rules, and under Pillar 2, tax incentives are neutralized under Pillar 2. Even the tax credits increase the denominator in the ETR calculation. My intuition would be that there potentially, and I didn't see that in Hersfeld's paper, that it's the tax incentives. That if we neutralize our own tax incentives under Pillar 2, and if the system is designed in a way that it's not neutralizing US tax incentives, then there potentially, I guess, is a competitiveness issue. And then, of course, we would have an interest. And then there's a political debate. And then, of course, at the end of the day, also a reason potentially for EU businesses to start litigating the matter before the courts. And if it's all technocratic stuff, then this whole discussion is hot air souffle. But I think we are too smart for talking on souffles and doing as if this is a serious topic. So that leaves me puzzled. But that is also I don't know enough about how the US system works. But I would be very interested also hearing about Latin American tax incentives that are potentially being taxed away by European top taxes. So I think much of the debate at the end of the day is about the real ETR and the real question about equivalence or not. And I think much hinges and involves the question as to what do we do under the system for these tax incentives, because I think there is a lot of interest, but potentially, at least, I guess, also for companies in their quest for strategizing on their tax costs. Yeah, thank you.
Thank you, Martin. Suranjali, the floor is yours.
Thank you. I just wanted to chime in to sort of reflect back on multilateralism. I think we're going back to sort of the first principles in terms of why we have Pillar 2. What does it really mean to have steered the entire process from saying that we wanted, unified approach, and then we say that we want, Janet Yellen mentioning that we want to tax top 100 companies in the US. And I think that's where OECD pivoted its entire program to Pillar 2, and now we have the US saying that it's not quite interested in the process. I feel that India and China in that regard have been quite practical to have taken a wait and watch approach in a sense, instead of importing all the complexity. But I think the stress point in terms of economics needs to be recognized. If you look at the statistics between 2017 and 2022, the effective tax rate for companies, the M&Es headquartered in the US actually declined from 30% or roundabouts to 21%. Whereas for the foreign affiliates, it's actually stabilized. There was also evidence to suggest that R&D activities have actually moved to the US. And with the TCGA, in a sense, continuing for the US, there will be more activities of such like being undertaken in the US, which means for the EU, it's a big question mark on what it means for its competitiveness. If anyone's read Mario Draghi's long report, it talks about how EU lost on its tech cycle. It lost in terms of innovation, not just because of tax, but also because of regulation. And so thinking about this legislation is actually quite important. If you look at the share of European affiliates in total US sort of revenues, number of entities, about 48% of US M&E headquartered in the US, their affiliates are located in Europe. About 62% of the assets are in Europe. Net income about 56%, which means that how EU and US decide on this particular proposal will have ramifications for both the countries. But at the same time, it also relays on how much you can achieve in the multilateral framework. Thank you.
Thank you very much, Suranjali. Indeed, I think that's really part of the lessons we need to take with us after this project. Irma, you had a question as well.
Yes, we have 5 minutes, but I cannot stop asking this question.
I give you the floor.
Because
Okay.
when we started with the EU directive, the Pillar 2 directive, I remember there was a conference, a presentation, where Benjamin Angel say, if we do not get all the countries, we go to enhanced cooperation. Then after there was the discussion with Hungary and Poland, the rule of law, and we got the directive. And then we think if we see right now what is going on and what the US and Europe is doing and all the countries caught in between, why are we doing this? Why is this issue? And Mohammed, we are colleagues, but I do not believe that neither the Pillar 2 nor the side-by-side system, nor it brings to really make the world better. And the same time, when you see is that it takes away the attention from what really the important issue is, to design the tax incentive. And I see this 2 weeks ago in Asia, in the Asian Development Bank, people who were talking about the Pillar 2 were just now talking about tax incentives, having transparency, having control, and so. So my question is, why are we doing this? Because Mohammed, I know you believe on this, but I do not. And I see that even we started with the directive wrong from the beginning. So this is my challenge.
Thank you, Irma. It's 4-4. So to finish on time, I would like to ask whether there are some final thoughts from the panelists, maybe basically following the order of the speakers. So Peter, Sean, Martin, Suranjali, Andrea, Mohammed, in this order, whether you have final thoughts. So Peter?
Yes, one final thought, and I really appreciate what
very short, please.
Yes, very short. I really appreciate what everyone was saying, and in particular what Sean highlighted, that the US did not want to govern other countries. That brings me to your question, Jérôme. How should future international projects look like? I think we need less global projects that have less impact on national legislation, because these projects will fall apart as we do not have the institution to govern them in the future. Thank you.
Thank you. Sean, a final word?
Yeah, I would just say thanks for having me. I would hope that in the future, international agreements are more practical and objective, outcome driven rather than theory and abstract and process driven. And I hope that Europe works in its own interest to be competitive in the future. So thank you.
Thank you. Martin?
Yeah, thanks. My final thought would be if Europe wants to tax itself, then we at least should have a discussion on that in Parliament. So I agree on what Sean was saying. Perhaps our people's representatives should think about EU interests a little bit more, perhaps. Yeah, thank you.
Thank you. Suranjali?
Yeah, I'd just like to say that I think we have to go back to looking at our tax treaties and tax incentives, which are a function of domestic policy. And what we have now is the baseline for international cooperation, which is exchange of information and a new normative standard for minimum taxes. So I think we move forward on bilateral basis from this multilateral consensus.
Thank you, Suranjali. Andrea?
Thank you, Jérôme. I totally agree with what Irma mentioned, because if there's something positive from the Pillar 2 discussion is the revision of tax incentives and to adopt best practices. But I think that there's no need to implement a domestic minimum top-up tax of the complexity of QD entities. In the end, if we are going to end in a widespread implementation of domestic minimum top-up tax, I think it's not worth it. The legislation proposed by the model rules. Yeah.
It's 4. Back to Irma for the final words.
Thank you so much. And I think that I appreciate that everyone spent 2 hours to discuss the side-by-side system. I want to say thank you to the speakers, to the participants, to Peter, the partner in crime in issues of taxation, I would say. Let's keep discussing all of this, and let's keep the discussion open. Thank you so much, everyone. Bye.
Thank you. Goodbye.
Bye.
Bye. Thanks.